Coinbase hearing was live yesterday, and the issue was it wasn't live. It was only recorded. So if you got on the conference call, you were lucky. What we did is broke this down for you guys. You're going to love it. It'll give you kind of a full run of all the clips and what really mattered from this hearing. My name is Paul Barron. Welcome back to the Tech Path. Let's just go right into it. There's several clips here we'll get to. We'll set up this first one, which is where and what the judge said about what is all this about. Listen in.
What is the conduct about which the commission complains? Precisely what it is that you believe Coinbase is doing as to each that runs afoul of the securities laws.
What we contend is that there are securities transactions that are taking place on Coinbase's platform, which would mean that Coinbase is currently operating as an unregistered exchange and an unregistered clearing agency.
So that just kind of sets it up of what the SEC is basically alluding to. We're going to go into this next clip because it gets into the questions around why and what they're trying to achieve with this motion to deny. Listen in.
I'd like to understand that a little bit more. I believe that Coinbase disagrees with you and says it's not that big a deal. But you've made mention of the uniqueness of it. I'd like to understand why I should care. If what you're arguing is that Coinbase is somehow, by providing these intermediation services, violating the securities laws, that the actual token issuers are themselves violating the securities laws. Is that correct?
Well, not exactly, Your Honor.
Okay. When the issuers decided to issue these tokens, SOL or SOL, for example, do you believe they were issuing securities?
If yes, Your Honor, yes, we were.
You're saying that as to these 12 or 13 tokens, when they were initially issued, these tokens were themselves securities?
Yes, Your Honor.
Okay. We're not claiming that Coinbase is the issuer. Are you arguing that they're a promoter in any respect?
A promoter of the offer or sale, not in the traditional sense of what you would call promotion.
Okay.
No, not in that context, no.
I mean, what's the third party that I care about here? The Howey test speaks to it. So what is the third? Is it the actions of the issuers themselves?
The focus is going to be on the actions of the issuer, and the developer and the project team together. At the end of the day, these 12 or 13 tokens, they are just computer code.
I'm smiling, sir, because that's kind of what your friends at the back table are saying, and they're wondering why we're here. So okay, yes.
And I promise, Your Honor, I will get you there.
So the SEC was having a little bit of a difficulty just trying to explain what the reason was. Judge Faya really was kind of in a position of not really having it. And this next clip, it shows her getting a little bit more frustrated with this. So you can kind of set up and see how this is going for Coinbase. Listen in.
When a customer opens an account on Coinbase and wants to look at different tokens to purchase and sees one of these 13 in particular as example, they can click on it and they can be linked right there to all of this information, including the value proposition for these tokens based on what these issuers and project team members are doing. So the focus...
Okay, but please pause. Had they not done that, would you still believe these intermediation services to bring them within the securities laws, and if so, on what basis?
Yes, the answer is yes.
But the thing about Terraform and the thing about Ripple, we're not talking about the issuer of the crypto asset. We're talking about an entity that put it on their platform. That, to me, is a level removed. And that's the concern I have about how these entities should have known. And you or your colleagues saying strict liability doesn't make me feel better about it. So I'm just confirming, at a minimum, the conduct was placing on the platform stuff that you now tell me amounts to a security.
Yes, the short answer is yes, Your Honor. Let me just clarify, though.
Please.
The token itself is not the security.
I understand that, right. And that's what, was it Mr. Hinman or someone else who said that? Someone from your shop who's no longer there had said that. So yes, token alone, not a security. So tell me what makes these the securities.
When they buy this token, they are investing into the network behind it.
All right, so she gets even more frustrated with this as they go further into what the SEC is trying to say. Listen in.
I'm trying to figure out what about these particular tokens allow you to make the argument that their purchase is not just the purchase of an asset, but the purchase into a system that implicates the securities laws?
Sure, Your Honor. I think the easiest answer to that question is that transactions in these particular 13 tokens satisfy the Howey test. That's what makes them security.
That's a little bit circular to me, sir. What is it about the issuance of these tokens? What is it about these tokens that brings them within Howey? And for you to say, will they satisfy Howey, is not a helpful answer to me. What is it about them? And please don't say Howey. What is it about them that you believe makes them securities? Thank you.
Man, she just wasn't having it. So this was still a good look for Coinbase. And I think this is a very pivotal point. I think a lot of people don't realize what kind of implication this is going to have on the markets, but more importantly, what this could have in terms of implications on legislation, regulation, and long-term outlook of the financial markets as a whole. So Coinbase kind of came out looking pretty good here. There's a lot more to cover here. I want to go to this next clip, which gets into actually targeting some specific tokens, including Chiliz and also XRP, going back to the win against the loss against XRP. Listen in.
If we look at the Chili token, for example, they launched the network and then they continue to expand and add value to it. Now, how does that play out in real practice? Well, if you look at Chili, the original white paper and its website feature biographies of the founders. In fact, in one tweet that they sent out, it's, quote, demand for CHZ exploded, going to bring a lot of value. And they also made efforts to drive secondary market trading by burning, and that's a term for, creating scarcity in the tokens to make them more valuable.
And so this is where you're disagreeing with Judge Torres in the Ripple case.
Correct, Your Honor.
So already been proven, and what she was talking about is Torres's findings on the Ripple case, which is established, the situation with XRP not being a security. The other thing that they get into was Bitcoin and why it basically was in a position of exception. Listen to what they had to say about that.
Perhaps you've seen tokens that where there was no ecosystem.
I believe that the commission has taken the position that the Bitcoin token is not a security. There's no ecosystem behind it, and I think that's the easiest way to look at it. Even with these 13, I don't know if I'm sensing Your Honor's next question or not, but
I doubt it.
By the acknowledgement, the concession that Bitcoin is a commodity, not a security. Bitcoin has every bit the ecosystem of these other tokens. Bitcoin is an ecosystem just like all of the others. And that won't do as a limiting principle as the Commission's own actions, we think, make clear.
All right, so actually that was the Coinbase attorney. They're on the other side of that in terms of the position on Bitcoin and their whole premise of how this plays out. And I think the key here, when you consider not only what the judge was trying to do, which was really just figure out, am I going to put a dismissal on this, or are we going to have to go to trial? Because that's really the result. There's a couple of options here that could happen as well. And we're going to get Meta Lawman to kind of break this down on, I think tomorrow. We'll do a video on that, because what this means for Coinbase stock, and also for Coinbase as a market leader and market maker is pretty critical to crypto. I want to go to this next clip because this goes into the SEC's staking defense, which was very weak. Listen in.
I found staking to be the least traditional investment-like of the functions that you were complaining about here. So I'd like to understand what it is about that. What is it that Coinbase does in the staking context that brings them within the ambit of the securities laws?
What Coinbase is doing is taking an established technology and building an enterprise on top of it. Investors are giving up their crypto assets to Coinbase's control. They are pooled, And then Coinbase is using its managerial efforts to manage the enterprise, which is the Coinbase staking program.
Well, I mean, you're both fighting over what is ministerial and what is managerial. So one of the reasons I'm asking you what it is Coinbase is doing is to figure out what it is you're upset about, what it is you think they're doing.
Yeah, Your Honor, that's a fair question. I just want to bring it back to staking on your own. It's complicated and costly, they said. Coinbase will do all of that for you. That is an investment
right, right?
contract.
I mean, they're
Absolutely.
right. Okay. What is the staking conduct that Coinbase does? I want it in gory detail. What is it that they're doing that you believe brings them within the ambit of the securities laws?
The validation needs to occur in a timely manner, and that's where the slashing risk comes into play. Coinbase provides maximum server uptime to allow for greater odds of success.
All right, so there was another topic that they hit on that was a pretty big fail on the SEC's part, and that was around the class action issues around tokens. Listen to what they had to say.
Let's say I agree with you. My concern is, does that mean that every crypto asset purchaser of those 12 or 13 securities can, if they decide they don't like what's happened, bring some sort of fraud action? What are the limits? Are there limits? Are there some guardrails in the commission's arguments? Because I am concerned, and several of the amici have suggested I should be concerned, that what you're asking for is too broad a definition of what constitutes a security. If you find, for example, that these are unregistered securities, I would think that in the first instance, the asset purchasers would have a right of rescission. Am I mistaken about that?
They would under Section 12.
So you've conceded that finding in your favor potentially opens up the gates to private actions. It's not merely the commission who can bring actions. There can be private actions by the holders of the individual tokens if certain circumstances were to happen, or at least if they were to be alleged. Yes, sir?
Correct.
Okay.
All right, so that was a big statement, and it was a big fail of the SEC around this. Could cause undue stress on courts, all these kind of scenarios of what they're talking about. The other thing they got into was collectibles, and this one was really bad because the judge actually, I don't know, I feel like the judge, very smart, she understands completely what's happening in this space. So she's asking the right questions. So listen to what she had to say about this.
I want to understand how your standard that you've just articulated to me does not sweep in collectible markets or commodities, which is my bigger issue.
We are not contending that collectibles are secure.
No one is actually suggesting that you are. We're all just afraid that you have so little limitation on your standard that some really thoughtful attorney is going to bring the Beanie Baby class action. Even now, you could forswear it right here. That doesn't matter. I care about how I know that your test isn't going to implicate either collectibles or commodities.
So if you buy a baseball card, for example, you're not buying into the baseball card player enterprise. Collectibles have, their own value. There is no way for somebody to make a baseball card more valuable. It can't be done.
In certain collectibles, I would have thought that akin to the burning that one has in crypto assets, you can have a limited edition figurine, or you could do something to limit the distribution of something, and that would increase its value. I'm just wondering if there are collectibles for which there is a group of people who are working together to ensure that there is a value. It's almost, you don't want to dilute the brand, as it were.
Sure, Your Honor, there is that possibility.
Yeah, this gets into a really slippery slope, and I think the judge recognizes this and the overreach that the SEC is trying to do. So they're already off to a bad start on this. And I think the continuous argument that Coinbase on collectibles is being so weak is kind of reiterated here in this next clip.
I am advised that there is an Apple Plus documentary about Beanie Babies that makes perfectly clear the communities that grew up around that. And it's true of all sorts of things that people buy and sell, the buying into a community. It is an absolutely vacant limiting principle. It's no limiting principle at all.
All right, so I've got 3 more clips, and you can see where this is going, around this. So the judge, very knowledgeable again, very also in a position of making it, I feel like, very easy for Coinbase to present their case. They go a little further because now we're talking about the regulation impact on Capitol Hill. So this is where Cynthia Lummis actually contacted the judge. Listen in.
I recognize that I have a lane that I should be staying in. There's a lane that you all are in. There's a lane that Congress is in. And I actually have received a brief from a sitting United States senator involved in this space who says to me, don't do this, Thela. I have to give that some deference, don't I? I mean, why is she wrong?
I think she's wrong, respectfully, to Senator Lummis, because one senator's view cannot override that Congress's will from 1934.
Okay, but she's not just random senator. She's someone who is deeply involved in the space and is herself a co-sponsor of legislation to implement the regulations or to implement a structure that she says is not found in the Howey test and that doesn't cover this specific group or type of assets. Why is she wrong?
And respectfully, Your Honor, I certainly don't.
By the way, you guys
think she
can
was
stop
random.
saying respectfully because I always wonder what that means. I always interpret that as some insult, some silencio or insult. So don't worry. So let's just go from there.
So, to take a step back, the authority to sort of overrule or repeal what a Congress duly enacted presented to the president for signature in 1934, that could create all sorts of issues.
Sure, but they're not saying they're overruling or repealing it. They're saying that we've had a great run. We've had 90 years for which these securities laws have been able to cover all manner of instruments, and now we've got something different. But I'm not sure. I don't know that this is necessarily a repeal as much as it is a filling of the void as to a particular category of instruments.
Well, we simply don't agree that it's like.
All right, so the judge, again, kind of dunking on the SEC around this from a regulatory standpoint. The fact that the SEC just kind of said, dismissed Senator Lummis was interesting because I think the point that the judge is making is that, hey, listen, we have senators that are well-versed in this. They're going to vote on this. They're going to make a regulation. So eventually this is going to go away. I might as well rule on this. This is the last couple of clips. One of them is going into the closing argument on from Coinbase. And this is a really strong closing argument. This is a good one to listen to. So let's listen.
I won't rehearse them all. I will also refrain from undue counterfactual historiography as to the question of what the congressmen and women of 1933 and 34 would have thought about this, but I'll tell you this. I think there would have been a lot of surprise to find that an investment contract didn't have anything to do with a contract at all. And that is the position that's being sponsored here, that the very words of that statute are being erased from it, completely in derogation from all the case law that preceded it. But slide 12 recounts about, maybe a dozen and a half statutory initiatives over the past 2 years where Congress is trying to figure out who crypto should be regulated by and how. I think there's an awful lot of surprise, historical and present, about the willy-nilly arrogation of regulatory authority that the SEC purports to assert by virtue of this action. I wish to insist that there has been no showing of a necessary limiting principle. The Commission's complaint draws the court into truly unprecedented territory. And if it's permitted to regulate here, it's permitted to regulate everywhere. And it could do so in after-the-fact enforcement actions, with or without notice, with or without warning. And that is not the way administrative law is supposed to work. And this is several bridges too far. And for that reason, we really urge the court to grant the motion.
Yeah, so this was a very strong position and argument there by Coinbase, and they hit it on all of the closing arguments better than I think the SEC did. The SEC really struggled with this, and I think a lot of people anticipated that they already would. But this really started to close the door on the SEC. Now, the judge gives us her final argument here, or final closing remarks. And there's some interesting things that Judge Fela said that I think could give us an idea that this is going to come to a conclusion rather than going to an actual court case. Listen in.
Earlier today, my deputy said to me with some horror, "Are you going to decide this from the bench?" And it only prompted horror on my part because no, I was clearly not. I had questions when I began this day. I have some answers, and I have some questions as I end the day. So I suppose I should thank you both, and it is a measure of everyone's preparation that I can't decide this from the bench right now. So take that as a compliment. It is.
All right, so there you have it. This is the wrap up. Basically, my assessment is Coinbase clearly had the upper hand. And I think that Judge Fela also understands what this means for regulation, what it means for markets, and what it means for the future, because this is going to end up being a lot more, just like what the Coinbase's closing arguments, this is going to draw in a lot more situations from court actions that really the court just doesn't have time for under this overreach of the SEC. If you look at Coinbase's stock, we'll go back here to December. Now, this is December 28th when it hit that all-time high at 186. This is all leading up to the ETF. But you look at it, Coinbase has been on a little bit of a slide now. So really trading around 124, and even yesterday I had a little bit of a closing around 130, 132. Point being is this has not had a big effect on Coinbase. Now, if you look at it from a standpoint of, is Coinbase maybe in a position where this could bounce and be beneficial if in fact we get a dismissal? If a dismissal comes in from the judge, Coinbase, and I think what we will see on a lot of these tokens, which we'll break down for you guys in another video, are really going to start to respond. So keep an eye on that. We'll try to keep you updated on all that good stuff. And of course, like I said, we'll have Meta Lawman giving us his opinion. This is an attorney's opinion who was there, where he thinks this could be going next. So it's going to be a good one. Make sure and tune in for that. If you're not part of the Diamond Circle, get in right now. It's free content. We do additional podcasts and research over there. It's very easy. Just click the link down below. Follow me on X @Paul Barron. We'll catch you next time right here on TechPath.